Welcome back, guys. It's been a while. So, just to get things started and rolling just right, a friendly reminder. Yeah, love my haters. But I always remember, people, stay motivated. Motivation is what it takes. So, I was going through emails the other day, and I received an email from a constitutional brother who goes by the name Constitutional Man, and he requested that the Dark Angel read the case Shapiro versus Thompson. Now, for those of you who don't know about Shapiro versus Thompson, if I can get it to cooperate, it was cooperating just fine a minute ago. Now it doesn't want to cooperate. But Shapiro versus Thompson is a 1969 case, okay, that, why is it not wanting to cooperate all of a sudden? That does just not make sense to me. Anyway, there it is. So Shapiro versus Thompson is a 394 U.S. 618 1969 case, okay. The case is actually, interestingly enough, is actually even going to cover some grounds on another video that I'm doing about the birth certificate and the settlement certificate, I should say. The settlement certificate, i.e. birth certificate. And I went online, and I've looked up and seen on YouTube a lot of people covering videos about the birth certificate. However, what I have not seen in a majority of these videos is the actual origin of the birth certificate, the history of it. So, and what the government thinks about you and your birth certificate. I've covered that in my One Country, Two Jurisdiction videos, a couple of case laws that came straight from the Supreme Court as to what they believe the citizens of the United States of America are. That they're just property, they're enslaved property, and I got a lot of feedback on that, a lot of fallout too, actually, which was kind of interesting because the haters, the trolls, and the traitors, they wanted to actually argue that it wasn't true, but then they all shut up and got quiet when I provided them with the Supreme Court case laws that actually said that exact same thing, that the United States citizen is nothing but a piece of property. They're a security interest, and they always have been, ever since the induction of the birth certificate. So that's another video for another time, but for right now, Constitutional Man, this one is actually going out to you because I do want to make sure that I express within this reading that this case is actually about the welfare system, okay, and it's a landmark case that was established. So let's get that straight. Let's make sure we all know and understand that. It was also a case used to establish the 14th Amendment right to travel. Now, even though the right to travel is not the basis or establishment of this case, it is part of the foundation of the case. Okay, the right to be able to ingress, egress from state to state for certain benefits. Okay, so basically what it's saying is when Miss Thompson decided to leave one area to go to another area to get better benefits for her family, for her children, she was denied the privilege. Okay, so it'll all be covered in this case. So we just want to make sure that everybody knows and understands that it will be covered in the case. So I just want you guys to know that that's what the basis of this case is about. So just so you know and understand, yes, the case is actually based on your right to free movement pursuant to that of the 14th Amendment. Okay, and also too, I need for you to understand and know that the right to free movement, for those of you that do not understand the expression free, okay, free means without interference, without regulation, stipulation. Okay, and you know, I've seen a lot of videos come out, and people, and what I do is I actually don't really watch the videos, because I know for a fact that the right to travel is legal. It's legal. It's perfectly legal. I've been doing it for 30 years, and I've only had four interactions with police over the 30 years, and I've won those 4. So, you know, you can take that for whatever it's worth, but to me it's worth a lot, because that's chevrons on my sleeve. So what people do not understand, and they want to continuously argue, is the fact that the state and the police power have the right to regulate transportation. You fail to understand something, people, when you come with that argument. Okay, first of all, you need to understand the origin and the basis of the DMV and the DOL. Okay, you keep, like I said, you keep wanting to utilize that expression. Well, the state has the authority to regulate any movement on its highways and stuff, etc., etc., etc. No, they don't. Nowhere in the history of law, nowhere has it ever been written that a state has been given the authority to regulate private travel and how to utilize private travel and what you can and can't do in order to privately travel. There is not one case law, and if you people can show me one case that specifically states, now listen to me now, I don't want to hear you citing cases that have no relation to private automobiles, because now you got to keep in mind, you have to learn to discern the difference between what a private automobile, private vehicle, and a private carrier are. Okay, because 9 times out of 10, the laws that are in relation to the private automobiles are in relation to them operating in commerce. And it seems to me that the great misunderstanding comes from everyone not understanding what commerce is. I mean, Jesus Christ, pick up a dictionary and look the word commerce up, and then go in your federal codes, okay, Title 49, I believe, and look up the definitions of commerce, look up the definitions of traffic, look up the definitions of transportation, look up the definition of driver, look up the definition of operator. Regardless of what you think it says, each and every single one of those words, even though they may not be commercial in origin, they are commerce, period, in origin. They are all commerce. And for those of you that don't know and understand, the DMV is a commerce corporation. Anything and everything that is issued and done through the DMV and or the DOL, Department of Licensing, is commerce. Every license, okay? You got to understand something, people. The DMV only issues one license. They always have, always will. And you say, well, there's a motorcycle license, there's non-commercial license, etc., etc. It don't matter what the name of the license is, people. It doesn't matter what name you think they threw on it to make it sound like it's a different license. The bottom line is all license. Did you hear me? All license issued by the DMV and the DOL are issued in commerce. Commerce means to do business and or trade and or transportation and or traffic, which is commercial. So commerce, the DMV, when you register your vehicle, your automobile, when you register your automobile, keep in mind, go back and look at my videos, and you'll see I actually covered this issue, because I really want to get off into this Shapiro versus Thompson for constitutional man. The DMV, as stated by the Supreme Court. Now, you guys seem to fail to understand the Supreme Court ruled on this. And a lot of people say, well, no, that wasn't in reference to that. Yes, it was in reference to that, because it's part of the opinion. Granted, it was part of the DPPA, which is your personal, personal private information or something to that effect, that when submitted to DMV, and then the DMV takes and sells your information. So it was part of the violation of the Privacy Act. Okay, but regardless as to what the substance or the body of the case was about, it's what's written in the opinion of the case that matters. Okay, and that's what a lot of people fail to understand. Supreme Court Justice Rehnquist ruled and stated that no state has the authority to force federal regulations on that of private individuals. It says it in the case, Reno versus Condon. Read that case. He says it in there. As long as no state forces federal regulations on that of private individuals, a federal regulation is anything dealing with commerce. See, and that's where you people keep getting confusion. Commerce, commercial, Commerce and commercial go hand in hand. They're brothers. They're twins. Okay? Anything dealing with commerce means business or trade. Anything dealing with commercial, of course, means business or trade. However, you have to understand that the DMV they're not government entities, they're private corporations. Any and all corporation operates under commercial code. Simple. I mean, do the math. I mean, it's not that freaking hard, people. It's perfect sense. Any and all businesses have to be in compliance with commercial code, which is federal. Simple. The DMV included. Even though they might be private corporations, private entities within the corporation of the United States, okay, the United States is a corporation. If you read the post that I posted a while back, you would have noticed that I actually showed to you 28 USC Code 302, the definitions, okay, and in that code it specifically states in there definitions. This is the code right here, just in case any of you are wondering. This is the code. Okay, there you go, right there. 28 USC 300.22 definitions. And as you can see, I'm doing it right in front of you, so that way you can't say, oh, well, you blotched that, you did this, you did that. No, no. What does that say right there? That says United States means a federal corporation. Oh, and by the way, in case you're wondering, this is per 2023. The United States federal corporation, people. Facts. Facts. How you utilize those facts, that's completely up to you. But this is facts, 100%. You can't dispute it. You can sit there 20 ways to Sunday, 15 ways to Monday, and try to call it whatever you want. And you can, because it's your right to do whatever you wish with the information that I'm giving to you. However, you can't dispute the facts. The facts is right there in front of your face. I just gave them to you. I just showed them to you. The government doesn't want you to know that. The United States sure as hell doesn't want you to know that it's a corporation, but that's common sense. It's a corporation. The government also doesn't want you to know that you're property. But, you know, I revealed that too. One country, two jurisdictions. Watch those videos. I actually tell you the case law, what they say, and what they actually think about you as a citizen. So therefore, with that being said, you know, I just want everybody to know and understand. The DMV is commerce, people. Reno versus Condon, Supreme Court Judge Rehnquist made it very clear in that case, two points of issues that he mentioned in his opinion, okay, that a lot of people overlooked, but didn't realize that being that it's based in his opinion, that's actually standing law, okay. One, he says, anything and everything associated and or coming out of, including information from the DMV, is commerce. You take in the regular dictionary, a regular high school dictionary, elementary school dictionary, regular school dictionary, and you look up the word commerce, it's going to say the exact same thing that the Black's Law Dictionary is going to say in the 11th edition, which is the new one that just came out, okay, and it's going to say business, trade, transport, transportation, and all these are commerce related words, or commercially related words, terms I should say, okay. So let's make sure we get that straight. So now on constitutional man, this is for you. This constitutional man, I want you to know, might be a two-part video, this being part one. The case is actually pretty long, so I just want you to know it's pretty long, okay. So here you go, right here you have part one, which is the first half that I'm going to try to cover in this video, and then you have part two. So I'm going to try to cover both of those, but not in one video. So I will have Shapiro versus Thompson 1, Shapiro versus Thompson 2, okay? So I want you just to, you know, kick back, relax, watch the video, enjoy the information, because it's coming straight from the books. Like I told y'all, I go to the law library and I read the books. You know, I'm not that guy that's going to sit there, oh, I'm going to copy that offline and I'm going to do this, and no. You know, because you never know who's online altering what and doing all that. So Shapiro versus Thompson, 394 U.S. 618, 1969. Let's get right off into it. The United States Supreme Court, Shapiro versus Thompson, number 33. This case was actually argued on May the 1st, 1968, and it was decided April 21st, 1969. This was actually 3 years after my birth and 1 day after my birthday. I was born on the 20th. Imagine that, 1966. So, yeah. Let's see what we got here. These appeals are from decisions of 3-judge district courts holding unconstitutional Connecticut, Pennsylvania, or District of Columbia statutory provisions which deny welfare assistance to persons who are residents and meet all other eligibility requirements except that they have not resided within the jurisdiction for at least a year immediately preceding their applications for assistance. Appealee's main contention on re-argument is that the prohibition of benefits to residents of less than 1 year creates a classification which constitutes an invidious discrimination, denying them equal protection of the laws. Imagine that. Which is practically true. It does create a discrimination. So appellants argue that the waiting period is needed to preserve the physical integrity of their public assistance program, as persons who require welfare assistance during their first year of residence are likely to become continuing burdens on welfare programs. See, now the government says, oh, you're a burden because you're on welfare. See? Any kind of way to detour the American citizen to control you. Now you are a burden because you need the assistance. So now you're a burden now. But they offer the assistance. But once you accept that assistance, you become a burden. Imagine that, people. Now you're a burden. So become continuing burdens on welfare programs. Appellants also seek to justify the classification as a permissible attempt to discourage indigents. Did you hear that? A permissible attempt to discourage indigents. Okay. From entering a state solely to obtain larger benefits, and to distinguish between new and old residents on the basis of tax contributions they have made to the community. Certain appellants rely in addition on the following administrative and related governmental objectives: facilitating the planning of welfare budgets, providing an objective test of residency, minimizing the opportunity for recipients fraudulently to receive payments from more than one jurisdiction, and encouraging early entry of new residents into the labor force. Connecticut and Pennsylvania also argue that Congress approved the imposition of the 1 year requirement in 402B of the Social Security Act, held in 394 U.S. 618, 619. So, continuing on, because I'm going to try not to narrate my opinions into this as much as possible. I'm going to try to just continue to read it factually so that you can hear the information. Okay, so the statutory prohibition of benefits to residents of less than a year creates a classification which denies equal protection of the laws, because the interest allegedly served by the classification either may not constitutionally be promoted by government or not compelling government interests. And you can see by my reactions that where this is going. In other words, what they're basically trying to say is even the government doesn't agree with some of the constitutional ramifications. Imagine that. So, Since the Constitution guarantees the right of interstate movement, now listen to this, y'all. Since the Constitution guarantees the right of interstate movement, the purpose of determining the migration of indigents into a state is impermissible and cannot serve to justify the classification created by the 1-year waiting period. So in other words, basically what they're saying is they're not going to utilize the fact of freedom of movement as grounds to justify the classification. Okay, so don't go in there thinking that that means something totally different, because it does not. Basically what the court is saying is we're not using freedom of movement as grounds, as the substance for this case. Okay, they're not using the freedom of movement. Freedom of movement, yes, is mentioned throughout the case. Yes, it is. But they're not using that as the basis to establish the opinion of this case. Okay, so freedom of movement is a guarantee. It's an inherent right. Everyone has it. Just you have some who has been programmed to accept the privilege and throw the right away under false pretenses, mind you, under false pretenses. Okay, all right, so the classification may not be sustained as an attempt to distinguish between new and old residents on the basis of the Constitution, on the contribution they have made to the community through the payment of taxes because of the Equal Protection Clause, because the Equal Protection Clause prohibits the state from apportioning benefits or service on the basis of the past tax contributions of its citizens. Okay. In moving from jurisdiction to jurisdiction, appellees were exercising a constitutional right, and any classification which penalizes the exercise of the right, unless shown to be necessary to promote a compelling governmental interest, is unconstitutional. Appellants do not use and have no need to use the 1-year requirement for the administrative and governmental process suggested, and under the standard of a compelling state interest, that requirement clearly violates the Equal Protection Clause. Section 402B of the Social Security Act does not render the waiting period requirements constitutional. Imagine that. That section on its face does not approve, much less prescribe, a 1-year requirement, and the legislative history reveals that Congress' purpose was to curb hardships resulting from excessive residence requirements and not to approve or prescribe any waiting period. Assuming arguendo that Congress did approve the use of 1-year waiting period, it is the responsive state legislation and not 402B which infringes constitutional rights. If the constitutionality of 402B were at issue, that provision, insofar as it permits the 1-year waiting period, would be unconstitutional, as Congress may not authorize the state to violate the Equal Protection Clause. Congress can't authorize anything that violates any clause of the Constitution unless it's been brought up as a bill and voted on legally. Keep that in mind, people. That's the only way. There's only 2 ways you can lose your rights: knowingly and voluntarily, and through Congress. So if a bill's brought up where something was passed by Congress that challenged your rights per the Constitution, and maybe changed your rights, deprived you of your rights, then, and it passes, hey, If you stand down, bow your head down, and don't sit there and bring up any type of argument in reference to that, well, guess what? They just encroached upon your rights legally, and you let them because you refuse to stand up for yourselves. And that's the problem with Americans today. They want the easy way out, and they feel that by not saying anything, everything will be all right. What are you going to do one day when you wake up and realize that maybe one day you're going to need permission just to step out your front door? You got to call a special 1-800 number just to be able to get permission to walk out your front door. Come on, man. I mean, is that possible? Sure. Anything's possible. With the way the United States is going today and these days, yeah, anything's possible. But anyway, my opinion. So, gonna get back off into this. So, let's see where we're at. Okay, so the writing on this case is so small because of its age, but they didn't think to blow it up a little bit to make it a little bit bigger for us. They can't actually see all that well, but it is what it is. So, all right, so now according to this, it says number 9, 270 federal supplement. 331, number 33, 279, Federal Supplement 22, and 65. Affirmed. Let's see, let's get into some of the words. Okay, so basically, I'm actually going to skip that part of the case because that's basically what they're saying is the case has been affirmed. The majority of the House actually ruled on this, people. So it's showing that damn near all the Supreme Court justices ruled on this case and ruled in confirmation with the initial judgment. So we're going to get off into some of the actual case because a lot of this case actually covers. Okay, so all right, so what we're going to do is we're going to go here. Also keep in mind, Shapiro versus Thompson actually covers 3 different appeals, okay, coming out of Washington, D.C., Pennsylvania, and Connecticut. So this is actually 3 appeals being heard at once. Thompson is just one of the 3 cases that's being heard, okay, and in the event that you don't know, Thompson is just one of the 3 cases that's being heard. So there's actually 3 cases going up at the exact same time. Okay, according to this, because here you go right here, it actually says right here, which I didn't even catch this until just now, so we're both finding out about this. These 3 appeals were restored to the calendar for re-argument, 392 U.S. 920, 1968. Each is an appeal from the decision of a 3-judge district court holding unconstitutional a state of District of Columbia statutory provision which denies welfare assistance to residents of the state or district who have not resided within the jurisdiction for at least 1 year, immediately preceding their applications for such assistance. Okay, and then the second one is, okay, that one was the District of Columbus. Okay, the second one is the Connecticut Welfare Department invoked 17(2)(b) of the Connecticut General Statutes 2, denied the application of appellee Vivian Marie Thompson for assistance under the Program for Aid to Families with Dependent Children. She was then a 19-year-old unwed mother of 1 child and pregnant with her 2nd child when she changed her residence in June of 1966 from Dorchester, Massachusetts to Hartford, Connecticut to live with her mother, a Hartford resident. She moved to her own apartment in Hartford in August of 1966. When her mother was no longer able to support her and her infant son because of her pregnancy, she was unable to work or enter a work training program. Her application for AFDC assistance filed in August was denied in November solely on the ground that, as required by 17(2)D, she had not lived in the state for a year before her application was filed. Okay, so let's see. She brought this action in the district court for the District of Connecticut, where a 3-judge court, 1 judge dissenting, declared 17(2)D unconstitutional. 270 Federal Supplement 331, 1967. The majority held that the waiting period requirement is unconstitutional because it has a chilling effect on the right to travel. Did you hear that? It has a chilling effect on the right to travel. I don't know if anybody heard that, but I hope y'all all heard that. Okay, so, and I'm not going to go into the chilling effect of as to what it means by them saying the right to travel. Well, yeah, I guess I will. Basically, what they're saying is because she up and moved from one place in Dorchester, Massachusetts to Hartford, Connecticut, travel right there between the two areas, okay, and fact of the matter is that she had an established jurisdiction, residency, okay. They're saying that it affect that. So at number 33, there are 4 appealees. 3 of them appealees, Harold Brown and Legrand, applied for and were denied AFDC. See, as I told you, it's three different cases mentioned in one case. So you have Harold, Brown, and Legrand, okay, and then of course the Thompson case. Were all denied AFDC, and the 4th appealee, Barley, applied for and was denied benefits under the program for aid to permanently and totally disabled. The denial in each case was on the ground that the applicant had not resided in the District of Columbia for 1 year, immediately preceding the filing of her application as required by 3203 of the District of Columbia Code. So actually you have 3, 4, actually there's actually 5 of these cases, okay, in reference to the AFDC that has been sent to the Supreme Court, all in relation to the exact same thing. Okay, so they're all in relation to the exact same thing. So there's that, you know. So let's see what the outcome was. Okay, so appealee Minnie Harrell, now deceased, had moved with her 3 children from New York to Washington in September 1966. She suffered from cancer and moved to be near members of her family who lived in Washington. Appealee Barley, a former resident of the District of Columbia, returned to the district in March of 1947 and was committed a month later to St. Elizabeth's Hospital as mentally ill. She has remained in that hospital ever since and was deemed eligible for release in 1965. And a plan was made to transfer her from the hospital to a foster home. The plan depended, however, upon Miss Barley's obtaining welfare assistance for her support, Her application for assistance under the program for aid to the permanently and totally disabled was denied because her time spent in the hospital did not count in determining compliance with the 1 year requirement. In other words, they weren't even considering what I would say or constitute as special circumstances, being the fact that she was in the hospital, under some. Now it was determined that she was diagnosed with cancer. Well, if you have a cancer patient, why in the world would you admit them to a mentally ill hospital? A mentally ill hospital is for like mentally insane, isn't it? I mean, I would think. But, again, my opinion, I could be totally wrong on that. Maybe mental hospitals were designed for something else back in the day. I don't know. I wasn't born in the 40s. I was born in the 60s. So there's that. For the love of money, people. For the love of money. Anyway, yeah, let's see what they got. So, Appealy Brown lived with her mother and 2 of her 3 children in Fort Smith, Arkansas, and her 3rd child was living with Appealy Brown's father in the District of Columbia. When her mother moved from Fort Smith to Oklahoma, Appealy Brown in February of 1966 returned to the District of Columbia where she had lived as a child. Her application for AFDC assistance was approved insofar as it sought assistance for the child who had lived in the district with her father, but was denied to the extent it sought assistance for the 2 other children. So because the one child actually lived there, the application was accepted, but as for the 2 children who did not live there and recently moved there, it was denied. Discrimination all the way around. Discrimination all the way around. And don't get it twisted. I do kind of somewhat understand the specifications as to the rules. However, assistance is assistance. If someone needs assistance, they shouldn't have to meet a how long you've been established requirement. Okay? The bottom line is people needs assistance, you give them assistance. Period. I don't care what the rule says. You can rest assured that if I worked in that office and I got those applications and I noticed that a child needed some assistance because the mother or father couldn't per se take care of them to the point to where it would help them, stabilize a family, I'm going to do everything in my power to approve that application. Because one thing for sure, 2 things for certain, being that the state has been given the authority to do whatever it wants to its enslaved citizens that a lot of people do not know and understand, one thing they have never been given authority to do is to starve the population. In the event that you're wondering. No one has the authority to do that. No one has the authority to deprive. I mean, it's a charge. It's an offense. You get a parent who starves their child. That's neglect. It's negligence. So, in my opinion, on this case here, on this particular case, by the state depriving parents from being able to provide support for their children, okay, that's negligence. File charges of negligence against the state, because that discrimination, that violation of equal protection of the law, it actually goes hand in hand, because apparently the statute that's in place for the 1 year requirement is a violation of law. It's a violation of the equal protection law, because you have the right to feed and provide for your child. no matter where it comes from, whether the assistance comes from the government, whether it's you working, and once someone who is deemed indigent becomes a ward of the state, okay, for the state to say that they are now a burden because they applied for assistance from the state, that's ludicrous. I mean, that's absolutely ludicrous, because you are classifying people. You're classifying people as indigents of burden. Food for thought, people, food for thought. So, Apelli LeGrant moved with her 2 children from South Carolina to the District of Columbia in March 1967 after the death of her mother. She planned to live with a sister and brother in Washington. She was pregnant and in ill health when she applied for and was denied AFDC assistance in July 1967. The several cases were consolidated for trial, and a 3-judge district court was convened. The court, 1 judge dissenting, held the majority rested its decision on the ground that the 1-year requirement was unconstitutional as a denial of the right to equal protection secured by the Due Process Clause of the Fifth Amendment. We noted probable jurisdiction. See, told you exactly what I was just expressing. It's a violation of the equal protection law. That's criminal. That's criminal. Where children are concerned, you're denying them food, assistance, health care. You're denying them just because of the parent didn't establish a 1-year tenureship in their jurisdiction. Come on. It's negligence no matter how you look at it. I mean, you as an adult and a parent, you was deny your child food and it got reported, you was going to be charged. So what makes the state think that it's exempt from being charged the exact same way you were being charged? You have a right to file negligence charges against the state for denial of food if that's the only source and means for you to be able to feed your child. I mean, what is the Child Protective Services, CPS? See, that right there is government human trafficking. And a lot of people don't even understand that. That's organized government human trafficking, CPS. And a lot of people do not understand that. Who gives the government the authority to come into your house and take your child at any will and prayer? I'm going to tell you why. When you signed that birth certificate, you practically signed over your child as property to the state, which, as I said, will be another video. I'm going to get off into that, and everything that I'm going to disclose to you in that video about the birth certificate is factual. It's 100% facts established. It came out of the archives based on what the birth certificate actually means. Birth certificate was actually used back in the day to settle a debt. Believe it or not, it was used to settle a debt. That's why they called it a settlement certificate until they adopted the name birth certificate later on. Okay? Exact same document. There's no disputing it. When we get into that video, you're going to see some facts and hear some facts that a lot of, like I said, on YouTube, there's a lot of videos out there that don't even know. They kind of touch and go on the grounds of a birth certificate, but they do not get into the nitty-gritty information as to what a birth certificate actually is. And the information that I'm going to reveal in that is not someone's opinion. This was actual facts that was found again, a lot of the information that I share with you people, you have to know and understand, is information that the government, the police, they don't want you to know. They don't want you to know this information. That's why they hid it. But you have people like me who refuse to give up on research and go research. And then you have the trolls, the haters and traitors who go in there, oh, you read law and you don't know how to interpret law. Obviously I do, because I've been doing what I've been doing for 30 years and only been confronted 4 times in the 30 years, and I won those 4 confrontations. So I obviously know a lot more than what you think I do, or what you give me credit for, because I've been doing it for a long time. You know, I didn't just start doing this. This isn't something that I just discovered, and decided I'm going to run with it. No, this is something I've been doing for a minute. You know, you can come here to my office that I have right here, and the information that I have here, that's just right here within this area of this desk, the books and the papers and things of this magnitude. And this is not stuff that I got off the internet, people. Everything that I'm providing you in and throughout these videos didn't come from the internet. Not a single one of them. All this stuff, the manuscripts that I read from, those come straight from attorney generals, Supreme Court justices, state prosecutors, friends that I have in those offices who go in through archives and find case law, you know, and they present it and they send it to me. Yeah, I opened the manuscript right in one of my videos to show you, hey look, I received this in the mail, you know, and I went through the index, or the, not the index, but the contents, and showed you who was contributing editors to that manuscript, you know. So, constitutional man, this case, basically, even though I said it was going to be a 2-part case, the writing on this case is so long, my guy, and it is just ridiculously long. This case is 600 and something pages long. I'm not, constitutional man, I'm not going to sit here and read 600 and something odd pages of this case. I'm not going to make a video on that. And I do apologize, because the case is basically, okay, the bottom line is that case is basically in reference to AFDC, the denial of applications for AFDC. And the more and more I read this case, even though, constitutional man, I just want you to know and understand, if you have any questions about this case, okay, you can email me, okay, at angeljohnson950@gmail.com. okay, you can email me with any questions, and I will gladly sit down and answer your questions. I just don't feel that the point of this case, in reading its entirety, actually stresses a point other than the fact that I'm going to tell you straight from the facts of the case. It is definitely a 14th Amendment precedent case that did in fact establish the right to travel. Okay, it did do that. So what I'm going to do for you is I'm going to go in here, and I probably should have done this way before I even sat down and started reading this case. I actually read the entire case, but I did not do like I normally do, quotate certain areas of the case, points of interest of the case like I normally do, because that's usually what I do, because it's those points that are stressed All you need to know with the Shapiro versus Thompson case is, yes, it does support freedom of movement per the 14th Amendment. Okay? It does. It's in there. It's in the footnotes, and there is over, and I quote, there is over 200 footnotes on this case. It's a lot of footnotes. This video's already gotten to be an hour long, and we haven't even gotten into any of the nitty-gritty stuff on the case. But I feel that, okay, so actually it's interesting. I just turned right to part of the case that might be of an interest to you. So, okay, so it says here, I therefore conclude that the right to travel is a fundamental right which, for present purposes, should be regarded as having its source in the Due Process Clause of the Fifth Amendment. The next questions are: 1. To what extent does a one-year residence condition upon welfare eligibility interfere with this right to travel? And 2, what are the government interests supporting such a condition? The consequences of the residence requirements is that persons who contemplate interstate change of residence and who believe that they otherwise would qualify for welfare payments must take into account the fact that such assistance will not be available for a year after arrival. The number of proportion of persons who are actually deferred from changing residence by the existence of these provisions is unknown. If one accepts evidence put forward by the appealees to the effect that there would be only a minuscule increase in the number of welfare applicants where existing residence requirements to be done away with, it follows that the requirements do not deter an applicable number of persons from moving interstate. Against the direct or indirect impact of the right to travel must be set the interest of the states and of Congress with respect to the District of Columbia in imposing residence conditions. There appear to be 4 such interests. First, it is evident that a primary concern of Congress and the Pennsylvania and Connecticut legislators was to deny welfare benefits to persons who moved into the jurisdiction primarily in order to collect benefits. This seems to me as an entirely legislative objective. A legislator is certainly not obliged to furnish welfare assistance to every inhabitant of the jurisdiction, and it is entirely rational to deny benefits to those who enter primarily in order to receive them, since this will make more funds available for those whom the legislator deems more worthy of the subsidy. In other words, what they just said right there basically is the government wants to pick and choose who they feel is worthy. That right there is a given. I mean, that right there is worded to exactly that extent. So if they feel that you're worthy, you're going to get it, and if not, you're not. Basically. But as you can see within the confines of the case, it does touch and go, as I said, on the right to travel. So basically what they're saying is they're depriving an indigent person from being able to travel from one state to another freely, unencumbered, to obtain benefits in another jurisdiction. Basically is what they're saying. So once you arrive in that state, you have to wait a year in order to receive the benefits. Again, it's criminal. Okay? So now listen to me now. constitutional man, because here's where I think the point that you're looking for meets victory. If the 1 year waiting period is a violation of the Equal Protections Clause, which it is pursuant to this case, okay, it makes the right to travel a violation of the 5th and 14th Amendments. Okay? So it's all confirmed. It's all affirmed within the case. So yes, your right to be indigent and travel to another state in conjunction to applying for AFDC, not having met the minimal requirement of 1 year waiting period, is a violation of the Equal Protection Clause. Yes, it is a violation of the Equal Protection Clause. Yes, it is a violation of your rights. Yes. So if that is what you are looking for, yes, 100. And a lot of people don't know how to put those two together, because you can't have one without the other. Because if you're traveling from one jurisdiction to go apply for a benefit or even a job or whatever the case may be, and you don't meet a certain minimum requirement, whereas residents who reside there do, and in a lot of instances in this case, a lot of them didn't, okay, because as you just heard me read, the government had the right to pick and choose whom they felt was worthy. So some kids are going to be chosen, some kids are not. All kids, for those of you that don't know, children who without a birth certificate are born free. The state does not recognize a child as a citizen. You're going to find that out when I read in the video about the birth certificate. You're going to find out the state never has recognized a child as a citizen, as a resident, as a member of its community. Child. Yeah, shocking. Don't want you to know that, though. They don't want you to know that. So with that being said, constitutional man, I wholly apologize if I did not go to the full extent of reading this case. I should have probably edited this case down to a point of, to where the facts of what it is, or you could have laid out to me and asked me exactly what it is about the case that what specifics are you looking for within that case, okay? But hopefully I answered your question, as far as, because I'm not actually sure, because you didn't give any type of information as to what it was exactly you were looking for in that case. The case is not per se about the right to travel, okay? The case is actually about the denial of applications for a 1 year waiting period for welfare, with mention of denial of the right to travel in reference to an individual who traveled from Dorchester to Hartford, Connecticut, okay, and was denied benefits. Okay, so basically the rule that is being mentioned there is that rule about the minimal 1 year wait period was designed to deprive, or not deprive, I won't say deprive, it was designed to discourage, that's the word I'm looking for. It was designed to discourage indigent people, citizens, okay, from traveling from one state to another to acquire benefits. That's what the entire case is about. Okay? The entire case was about discouraging the less fortunate from going into another state and acquiring benefits by them not having met a requirement that violated the Equal Protection Clause. Okay? So, like I said, I apologize. Yeah, we did get into a lot of the case, but the case is, like I said, it's 600 something pages long, my guy. And I just don't see that, me reading that entire case, that's going to take forever. It's going to be like 4 or 5 videos. And I'm already at 1 hour and 5 minutes, going on 6 minutes. And yeah, granted, I'm sorry that I put in a lot of my opinion and things of this magnitude, but on the same strength, my opinion as far as the case goes is based on facts that's been read within that case. So with that being said, like I said, I laid out my email address. It's angeljohnson950@gmail.com. If you or anyone has any questions, leave me a comment in the comments down below, letting me know that you will be emailing me, and make sure that you leave your email address or where this email that you'll be sending me is coming from. This way I would know what I'm looking for when I go through my email, my inbox, and I see these emails, because it's not every day that I sit down and actually read emails. Okay, so my inbox is full of emails all the time, and if you do not have specifics as to what your email is that you are sending to me, I will 9 times out of 10 overlook it and probably by accident, not on purpose, delete them. Because I just go through, and if I don't see anything in relation to constitutional anything, I don't pay it no attention. And I get a bunch of bull crap emails all the time. And I'm just the type of person that I'm not going to sit there and waste my time reading all these emails that are in reference to nothing. So with that being said, this is Dark Angel. I'm out of here. I'm going to get up off of here because I still have I have tons of videos that are coming, and there's going to be so much information. Like I said, I'm not, if you like it, if you don't. If you subscribe. If you don't. Like I said, I'm not on here for the popularity. I'm on here for the educational aspect of it, because I love the haters, the traitors, and I love you guys. And I'm not saying that you, Constitutional Man, per se, is a hater, because with the name Constitutional Man, you obviously are not a hater. You're obviously someone looking for some information and or help in reference to whatever it is that you're involved in. So I personally, one-on-one through emails, will be more than happy to accommodate you, any questions you should have. And that's anybody. That actually goes out to everybody. If you have comments, questions, if you want to send me certain documents and have me review them, look at them, go over them, send them, and send them to my email. Send them in a PDF form so that I can print them off, and I will review them, read them, and I will go over them, and we can discuss them that way, free of charge. I don't charge, As you notice, if you look down in any of the deals, I don't provide any links to Cash App. I don't provide any of that. Oh yeah, you can buy this, or you can make a donation for that. If if anyone ever feels that they want to do any of that, contact me and let me know. Hey, Dark Angel, I'd like to contribute. You know, make a contribution to your cause. Yes, going to the law library and all that takes funds and things of this magnitude, but I manage. I do it and I enjoy doing it. It's something that I actually have a passion for. My wife actually says that she's never seen me have such passion for something the whole time she's known me. And I told her, I said, well, this was way before I started with you or met you, that this had been established. I'd been doing this for a long time. And it's something that I love doing. I just put it on the burner, having just newly met her, and not knowing exactly how you would feel about it. However, I didn't really care as to what anyone felt about me standing up for constitutional rights. You know what I'm saying? I don't. You can agree or disagree. And you can agree to disagree, or whatever, To me personally, it doesn't matter one way or the other, because regardless as to who supports me and who does not support me, the bottom line is you're never going to get me to detour from my beliefs. Okay? Once I set my mind on something and believe it, and know that it's facts, you're not going to change my mind. If you watch one of my videos, I can't remember which one it is exactly right off the top of my head, but it makes mention of one of the presidents. I believe it's Warren G. Harding, I believe. One of the presidents from the past. The private papers. There's a young lady within the video. She is reading private papers from Warren G. Harding. Y'all need to go and I will find out what the name of that video is that I did. I did it myself. It's my video. I will find out what the name of that video is, because I think you guys need to listen to what she is reading from the private papers of this president, where he's actually disclosing to America, him and some other gentleman, that if the Americans find out about the program and how the corporation is actually run, that they will instruct the courts and the police power to act stupid, as if they don't know what they're being talked about. As for instance, your right to travel. And the cops act like they don't know. That's because they've been instructed to act like they don't know. So you need to watch that video. It's very, very informational. Watch all my videos. Watch them all. Because everything in there that I'm telling you is facts. 100% facts. Now, I'm not giving you law advice, so I'm just making this disclaimer right now. I'm not giving you law advice, and I'm not telling you to go out there and use it, but I am going to tell you this. Use it at your own discretion. I will say that, because, they want you to put a disclaimer up there, you're not a lawyer, this, that, and the other. I'm not a lawyer, but I am a paralegal, certified paralegal. I am that. So with that being said, because I'm not a liar, I would think that advice coming from a certified paralegal, one who actually does the work of the liar, the information would be more validated, have more credibility. So I'm going to tell you like this because this is how I feel, and I don't care what the rules are and what they say or anything of that magnitude. What I'm telling you is factual. It's 100%. What you do with it is your business. Okay? So that's how I'm going to leave that. And with that being said, this is Dark Angel. Like I said, I have too many videos that I got to get into. This video got a little bit way too long, which is okay. Constitutional man, again, my greatest and most humblest apologies for having not sat down and actually read the entire case. I would prefer to consult with you one-on-one through an email. I dropped my email, and actually I will actually put my email in the comments below for you to actually read, and I will leave you a message letting you know that the video is up. Okay? So with that being said, again, much love, brother. Fight your fight, do what you're doing. To all of my constitutional brother and sisters out there, much love to all of you. Shapiro versus Thompson, yes, put it in your arsenal for a right to travel. Yes, it is one of the landmark cases. So yes, it is a landmark case that has not been superseded or overturned by any other court decision. So yes, you can utilize that case in your arsenal for right to travel. Do not use it respectively as a main body source for a case, no, because there's way more powerful right to travel cases out there. However, this case is powerful, don't get me wrong, it is powerful, but I would use it as a supporting case. Okay? So with that being said, this is Dark Angel. I'm out of here, people. Deuces.